Hello and welcome to this webinar, which forms part of the New Model Business Academy's Professional Development Programme for 2016. In order to complement the comprehensive face-to-face events programme, NMBA will be hosting a number of webinars throughout the year which are designed to assist financial advice professionals with the application of their advice. NMBA has created a professional development framework which not only includes technical knowledge but also covers conduct and ethics, business development, practice management and personal development, all which should form part of any individual's annual development programme. Each of the NMBA webinars for 2016 will cover at least one of these areas, therefore providing a wide range of varied content for members to use for their annual professional development. As the content for these webinars is designed to support the application of advice rather than being purely educational, it can be used for unstructured CPD if required. The title of this webinar is Get Me an Attorney. I'm Tom Hegarty, Managing Director of NMBA, and I'm joined by Martin Lyons from Partnership. For many people heading towards a long-term care need, the need for a substituted decision maker is a key area. Whether it's to assist with decisions on health, wealth or a combination, establishing a lasting power of attorney is the key part of later life planning. After all, in many cases, their immediate point of contact for those going into long-term care is a family member rather than the client themselves. But whilst the area is often associated with the care market, the development of freedom and choice in the pensions arena means that many individuals will be making difficult decisions throughout their retirement years, whether long-term care is needed or not. Who makes the ongoing investment decisions or requirement for income if the client loses mental capacity? What happens if they lose the freedom to choose for themselves? In this session, Martin will consider how you can help clients and their families understand the need for a substituted decision maker and the duties that fall to an attorney. By viewing this session, advisors will be able to understand the need for a substituted decision maker, explain the duties of a lasting power of attorney, and examine the different types of lasting power of attorney. Martin has been in the financial services profession for over 28 years, working with local, regional and national IFA firms. Coming from a pensions specialist background, Martin joined Partnership in 2009 to focus on the retirement market and has been delivering face-to-face workshops and online webinars on pensions and retirement-related subjects. He now heads up a team of specialist business development managers working with advisors across the UK. So I'm just going to hand over to you now, Martin.
Great, thank you very much, and obviously I'd like to add my welcome to that of Tom's for this session. Get Me an Attorney. Sounds like some kind of a US cop show title, doesn't it? But I assure you it's going to be far more exciting than that. As Tom mentioned, freedom and choice is great to have. We've done a number of webinars on that subject, but given the fact that, people might stay invested for a longer period of time, is there perhaps a need at the point of retirement to make sure that if a substituted decision maker might be needed at some point in the future, that individual is kind of appointed at that particular stage, at the early stage as possible, and we'll go on to see exactly why that is. Learning objectives Tom's been through, understanding the need for a substituted decision maker, what happens at freedom and choice if somebody no longer has the freedom to choose, and what are the duties of that decision maker, in particular a lasting power of attorney. Now, a lasting power of attorney isn't the only type of power of attorney you'll find out there, so we'll go through briefly what the other types are, and there are two different types of LPA that are available as well. But we're centering here particularly on the retirement market because of this responsibility that people have been given to access their pension more flexibly. And as we've said in previous sessions, that is great news for financial advisors and clients who can now experience more tailored outcomes given the flexibility on offer. But there is a trade-off in terms of the access to this flexibility that we now have. And that trade-off for advisors is simply this. Looking at the Mental Capacity Act 2005, there is now a need, if there wasn't one before, to really understand the framework that governs financial decision making for those with restricted mental capacity. If there is no default option, into annuity as if there were previously, and more people are staying invested, certainly into later life, the trade-off is to understand what happens when mental capacity becomes an issue. Those clients may still be within that drawdown scenario, or indeed have a further need for long-term care. The retirement journey is clearly not just about the immediate pension any longer. What do we mean when we talk about capacity? Well, this is the Mental Capacity Act 2005 and their definition, sort of slightly paraphrased. But a person lacks capacity if at the time a decision is needed, they are unable to make one because of an impairment of or disturbance in the functioning of the mind or the brain. Now, it's an interesting statement there, of course, because it says, if at the time a decision is needed. In other words, this could be something temporary, it could be permanent. Certainly when we look at the care market, you sometimes find individuals that have a certain mental capacity as they enter a care home, but actually their capacity actually improves. And again, when it comes to retirement and some of the things we've spoken about in terms of vulnerable clients in a previous webinar, again, we can learn that some of these things may not be a permanent situation. And because of that, it actually makes it a requirement really to manage people's circumstances in as flexible a way as possible. So in terms of assessing capacity, what we're looking at here is, under the Mental Capacity Act, can an individual make a specific decision? Not what is their mental capacity like overall, are they capable or incapable generally, but can they make the decision that they're actually being faced with? And it's also capacity to understand, not wisdom. One of the papers that the FCA came out was DP 16.1, which is a discussion paper around how we address an aging population from a financial services perspective. And what it draws out in that, in one of the sort of specialist sort of sections of that, is really this understanding that people have accumulated knowledge, and then there's knowledge about new concepts, and the two can be very different depending on how recent that knowledge has been attained. So it's capacity to understand the point we're talking about, not wisdom even that's been driven by experiences, life experience and so forth. And it's not a constant. A client could have good days and bad days. One of the questions we had recently was, if somebody has a lasting power of attorney who are making decisions for them and speaking to a provider about those decisions, and then the client has a period where actually their cognitive ability improves, can we then revert to seeking the views of the client rather than the LPA? And the answer to that is yes. And there's no specific test to determine capacity, so it can be quite a complex area. What's the psychiatric opinion? Has the client gone through a mini mental state examination? How do we make sure that we're actually treating the customer fairly and ensuring that they can make decisions if it's possible for them to do so, but then we revert to a power of attorney who will act fairly if that's not the case. Now we talk about incapacity, cognitive ability being affected in later life, and whilst we're talking about perhaps the earlier stages when we enter retirement, it is important to remember that incapacity can occur at any time. So if somebody's in a position where they can appoint a substituted decision maker for now or for in the future, then that decision should be taken relatively early. And we've seen this in the world of sport and celebrity. Not many clients do this. One of the examples one of my colleagues uses, not many F1 clients out there, maybe you have some, but how many clients do sort of the normal sort of holidaying, doing ski resorts, whatever it might be, and we've seen from the world of celebrity that actually incapacity might not be because of somebody's occupation, but it might be from something completely different. Incapacity can occur at any time, so let's make sure we get this advice issue covered off early on. Particularly pertinent to drawdown, of course, or with the retirement market generally, is now being highlighted through various articles. This is the one from This Is Money, but really drawing out the importance of having that power of attorney, that substituted decision maker, particularly when people are remaining invested within drawdown. What happens if they fall ill? Has that been covered has that person appointed an LPA. You may have seen our Vulnerable Clients webinar. It goes alongside this one, and we talk a little bit more about the various circumstances clients might be in which makes them vulnerable. And certainly the Mental Capacity Act really sort of builds on this in terms of this specific area of cognition and cognitive impairment. So what if the freedom to choose during retirement is lost? And the question is, is an LPA going to be required? And I would strongly suggest in most cases, in a lot of cases, the answer to that would be yes. Now, with power of attorneys and the acts that sit behind that, it's important to remember that whilst we're focusing on the England and Wales side of things, there are sort of mirrored legislative documents in Northern Ireland and in Scotland. In Scotland, you've got the Adults with Incapacity Scotland Act 2000, and in Northern Ireland, you've got the Mental Capacity Bill, which was slightly behind in terms of royal assent, but nevertheless, these documents kind of complement each other. They effectively have the same principles embedded within them. And the common theme is this: to ensure those who lack capacity can make as many decisions for themselves as possible, to encourage people to make decisions. And decisions made on their behalf should be made in their best interest. No surprises there. It seems fairly common sense, but clearly you do get into areas where there are conflicts between family members, different thoughts, different perspectives on what an individual might decide. If they were at an ordinary place in terms of cognitive ability, we want to make sure that the views are taken into account to make sure that the client still remains the client. Here are the 5 principles of the Mental Capacity Act 2005, and again, these are generally consistent across the Scotland and Northern Ireland, the draft legislation and the enforced legislation. But that presumption of capacity, the substituted decision maker should only really be making decisions where the decision cannot be made without that substituted decision maker stepping in. If it's possible for the individual to make the decision by themselves, then that should be done. So individuals should be supported to make their own decisions, and in fact encouraged to make their own decisions and manage their own affairs. And also there might be the potential to help them develop skills, to increase their understanding if that's needed. So to develop skills to help them to make decisions. And individuals' decisions, of course, should be respected, and those decisions must benefit that individual based on perhaps their present and past wishes, their feelings as far as possible. Are there any other people that are close to that individual, maybe even carers or people that see that person regularly, any other views that need to be taken into account so we can ensure that the individual's decisions are respected? And everything must be done, obviously, in the best interest of that individual. As I said earlier, the client is still the client. When we get to the care market, where a very, very high percentage of advice is given through the substituted decision maker, the power of attorney, again, it's just worth remembering that that individual is acting on behalf of the client, not themselves. And according to this principle of the MCA 2005, we should be looking at the least restrictive option. So the minimum necessary to achieve the purpose that the individual wants to achieve, and to restrict their own individual freedom as little as possible. So this is all in the Mental Capacity Act guidance that can be found online. So it's important that these rules are followed for every single decision that needs to be made, and at the time the decision needs to be made. And just because you can't make one decision at one time doesn't mean you're unable to make all decisions at that time or in the future. It's decision specific, as we talked about previously. Again, just to reiterate, you're acting on behalf of the client, not the power of attorney. You can get conflicts sometimes, but even with a power of attorney, the client is still the client. So what do we need to put in practice to make sure that conflicts of interest are dealt with? Well, we go back to our Casley consulting document, publicly available on the internet there, that Ned Casley has produced, and there are some good pointers here actually in terms of making sure it's the client's best interest we're considering. The first one is not to assume, based on age, condition, or appearance or behaviour of that individual. We shouldn't be just making assumptions. We should really be getting into the thoughts process of that individual might be having around particular issues. As I say, make sure that their best interests are at the heart of things. Let's not generalise or make assumptions around what that individual might need or want. The other one is, can the decision be postponed? If the client is facing additional vulnerability for whatever reason, and again our other webinar talks about that, and they're in a position where they're unable to make decisions at the moment, but potentially there might be circumstances specific to that whereby that decision could be made later. Is it possible to postpone that decision? Can the client still be involved to any degree? So it's not enough to say, well, the client is unable to make this decision. Have we explored every avenue? Can we give that client some responsibility for decision making, even if ultimately the LPA has to step in? And as I mentioned before, consider the views of others, e.g. people that might be caring for that particular individual. The other thing is, we have to mention it, but it is one of the key things that's highlighted in this particular paper in terms of conflict of interest, and that is, of course, not to be motivated by a wish to bring about death. Now, I know that sounds very morbid, but nevertheless, it's the interest of that individual that has to be at the heart of the issue. Now, quick history of powers of attorney. They have changed over the years. Initially, you had an ordinary power of attorney, which was general or specific to one or more areas, and the powers of attorney could act jointly or independently. So you had to decide whether it had to be a joint decision, or each power of attorney could make any decision around those areas that were specified in the document. But the interesting thing here was that the power of attorney was actually revoked when the client lost mental capacity. Now, bearing in mind that that's perhaps when they become more vulnerable and where you perhaps need a substituted decision maker, things had to change, and that's why we had the Enduring Power of Attorney Act of 1985. That's now been superseded by the Mental Capacity Act 2005 and Lasting Power of Attorneys, but there are still some enduring powers of attorneys out there. Now, the Enduring Power of Attorney, if you do come across clients with those, gives the power of attorney the ability to act in the event that the client loses capacity, but must be registered at that point. Now, with an enduring power of attorney, these can be used before capacity is lost, so the individuals have the choice in terms of whether to affect that pre or post loss of capacity, but where capacity is lost, then the power of attorney cannot be used until it is actually registered with the Court of Protection. Again, powers can be general or restricted, and attorneys can be single or joint, but one of the key things in the enduring power of attorney is that it really only dealt with finances. It didn't include personal welfare, and that's one of the key reasons why a lasting power of attorney came in, the two types of LPA, to cover that off. So you can't write new enduring powers of attorneys, but those that are signed off before 2007 are still valid. What we have now for new LPAs are two different types. You've got the Property and Affairs LPA, called the Continuing Power of Attorney in Scotland, and then you've got the Health and Welfare, or in Scotland the Welfare Power of Attorney as well. So prior to this, again, under the Enduring Power of Attorney, it didn't cover health and welfare, but now you've got this document where you can specify that decisions can be made by an LPA around sort of the more personal issues, where you should live, your medical care, what you should eat, who you should have contact with, and so forth, what social activities you should take part in. So that is obviously a key reason for having an LPA rather than an EPA. And then on the property and affairs side of things, buying and selling property, paying the mortgage, investing money, paying bills, and so forth. But for me, this is the real important one as well for pension planning, because if a individual doesn't affect a lasting power of attorney or have something already in existence, then even their spouse cannot make decisions on the level of income, where they might be invested or anything else if that member loses capacity. Even a spouse or partner cannot make those decisions unless they have this substituted decision-making process in place, or of course for each decision they go to the Court of Protection each time, which obviously can be quite a cumbersome thing to do. How much discretion is allowed for finances? Well, LP12 is a good document to have a look at. That will really give you most of the guidance around affecting lasting power of attorney. There are some specifics in there. If you have investment managed by a bank and want that to continue, or you want to allow your attorneys to let a bank manage your investments, that has to be specified in the LPA. Where it comes to things like financial advice, whereby it's not a bank, but you might specify that if there's any financial decisions to be made, a financial advisor should be consulted. Perhaps if it's over a certain amount of investment, that's probably a good idea to perhaps put in there as well. And the other area that's worth mentioning is that if the LPA has already been registered, the attorneys will have to apply to the Court of Protection if they want to use a discretionary fund manager. So again, if discretionary fund management is in there, it's worth making mention of that in the LPA documents itself. So in terms of enduring power of attorney, lasting power of attorney, there's a table of the main differences. Again, one of the key ones there is the coverage of personal welfare, and the fact that under the LPA, you've got the ability to continue to be able to use the LPA if capacity has been lost, and it just gives that higher degree of protection for the individual because you've got the personal welfare and the financial side of things as well. In terms of making lasting power of attorney, well, okay, individuals could do that online themselves, but clearly we would suggest that it's a great opportunity for advisors to link up with a professional connection, a solicitor, to ensure that the power of attorney is done correctly. And you can refer clients down that route, of course, which again, we all know the opportunities there in terms of networking, reciprocation, and so forth. An excellent opportunity to tie up with professional connections. In terms of the costs, in terms of registering an LPA, £110 registration. Obviously, those solicitors' costs may well vary, and the number of attorneys you might have can vary as well. And you've got the option to allow them to act jointly and severally. So it could be a case that all decisions have to be made jointly, or indeed it could be a case that any one of those attorneys can make a decision on behalf of the client. And so again, those are the other sorts of decisions that need to be made. How do we want to set this particular issue out? The benefits of doing an LPA, of course, as I kind of alluded to there earlier in terms of the pension side of things, is that it avoids time delays. If you have this sorted out up front, perhaps at the beginning of retirement, then you don't have to apply to the Court of Protection for each decision as and when it's made. So the client, has some control via their LPA. And of course that Court of Protection process can be quite lengthy, especially if you have to apply every time a decision is made. Now, I said that LP12 gives you some good guidance on these issues, what needs to be included in the LPA, the considerations to make. But the LPA must be signed by a certificate provider to confirm that it's been understood and that the client hasn't been put under any pressure to sign it. And it's, as a protection for that, you're talking to somebody really who must be obviously at least 18 years old, an adult, that the client knows well for at least 2 years, or they've got some professional standing, doctor, social worker, solicitor, so they've got some added kind of credibility and professionalism. They could be a professional LPA. And the LPA must be registered with the Office of the Public Guardian before it can be used. Now, on top of this, of course, you've got the CARE Act 2014. So that introduces the Wellbeing Principle and again builds on the Mental Capacity Act 2005, focusing on the needs and goals of the person concerned, not just in terms of finance, but in welfare and well-being as well. So again, if the individual is going to a care situation, you know, the capacity issue is clearly a key one, and the CARE Act cross-references to the MCA 2005 when it comes to these particular issues. If the person doesn't have an LPA, well, the local authority has a duty to appoint an independent advocate. If they haven't got somebody working on their behalf, it's got to be independent from the local authority where that individual has got substantial difficulty in being involved and no one is appropriate or there to support them. So again, another key reason for having a lasting power of attorney in place, so you don't necessarily have to fall back on that service. You've got to absolutely ironed out what happens in the event of a loss of capacity, whether it be to do with pension, care or anything else. So there's lots of points to consider in terms of power of attorney. As you've probably heard from what I've been saying, it's a case of encouraging clients to execute a power of attorney. Dealing with that court of protection takes time and costs client money. So in doing the advice on this up front, you actually save a lot of time potentially in the future. You can't accept instructions without one or the other, a lasting power of attorney or dealings with the court of protection. That includes decisions around income drawdown and long-term care funding, which obviously is key to what we're talking about here. Families cannot make decisions without a power of attorney or deputyship, and arguably a power of attorney is just as important as a will. Lots of information at LP12 I've mentioned. You've got the Office of the Public Guardian website as well, and you've got the Society of Later Life Advisors, again with some key information on how you deal with a vulnerable client, and of course specifically looking at the importance of a lasting power of attorney. And in terms of the Later Life Accreditation syllabus, I'm not sure you can read all of that, so just highlight the part on that. It is actually part of the Later Life Accreditation syllabus. So again, if you're going down that particular route, lots of information, and you can obviously show that you've taken into account that particular aspect of your professional knowledge as well. So there's lots more information about this. Obviously, it's a bit of sort of a high-level view of the importance of power of attorney, but hopefully there's some food for thought there and some places to go should you wish to find out more information. And of course, you can always contact us at partnership.co.uk or by calling your normal point of contact here at the office. So thanks very much for listening. I shall pass back to Tom. Thank you.
Excellent. Thank you, Martin. Well, we hope that you found that session useful and you can use the knowledge from that to improve the advice you deliver to your customers. If you have any feedback on the webinar or require any further information, please contact Partnership directly or alternatively contact NMBA by emailing us at info@nmba.info or calling us on 01484 439 200. On behalf of NMBA, I'd like to thank Martin and Partnership for supporting the session and sharing their expertise with us. Please look out for other NMBA webinars that will be available to you throughout the year, and thanks again for watching.